Hello, my name is Mikola Gnatowski, and I'm very happy to be one of the lecturers of ELSA's Summer School on International Humanitarian Law. I have to apologize for not being able to participate in the school in the online mode, as unfortunately the timing of the school has coincided with my other commitments. But I'm very honored to be part of this project and to offer you a lecture on the applicability of international humanitarian law and on the classification of situations of violence to which IHL is applicable. I also hope to be able to answer your questions in another video. In the meantime, I would like to congratulate you on your choice of the summer school. I think that international humanitarian law is certainly very much worth every minute that you spend to master it. Especially this is, of course, true in Ukraine, which has experienced the applicability of international humanitarian law, that has experienced war on its territory only now, and it is important that you understand the peculiarities of the legal framework that exists to try and regulate such situations. I will cover today in my lecture the importance of the classification of the situations of violence and in particular of armed conflict and various situations to which international humanitarian law is applicable, and of course trying to separate them from the situations to which IHL is not applicable. So it is axiomatic that IHL governs the conduct of participants in an armed conflict. In other words, not any situation of violence is as such can be regulated by international humanitarian law, but only something that is called an armed conflict. And it is necessary to define such situations of violence, and it is important to understand which of them amount to an armed conflict and which of them do not amount to an armed conflict. What makes it a rather challenging task for lawyers is that international humanitarian law does not operate with one single concept of an armed conflict. Instead, it recognizes two separate types of armed conflicts: international and non-international armed conflicts. The reality, as it often happens, is not necessarily the same as the law, and sometimes it is not only complicated to separate an armed conflict, a non-international armed conflict, from a situation of violence which does not amount to a non-international armed conflict, but also to see how sometimes it is very difficult to give the correct answer to the question whether a situation is an international armed conflict or a non-international armed conflict, or perhaps, as it is suggested by many scholars, and also by the lawyers from the International Committee of the Red Cross, whether actually two types of this classification, two types of armed conflict can be invoked simultaneously. That is, a situation which can at the same time be classified as an international and as a non-international armed conflict. Let us now quickly go through the history of international humanitarian law and how actually we ended up with the current situation when IHL is applicable to international and non-international armed conflicts. You probably know that in the classic international law, that is international law that was born after the Peace of Westphalia in 1648, international law was only applicable to wars between states, and anything happening within a state, even when a large-scale violence was taking place, could not be regulated by international law, but instead was seen as domestic affairs to which no one could interfere, into which no one could try and apply or embed international rules. This situation only changed after the Second World War. And of course, before the Second World War, there were attempts to use the law of armed conflict or jus in bello to civil wars, especially in this respect, the Spanish Civil War that took place in 1936, 1939 stands out. But in essence, international law regulating the armed conflict was not applicable to any civil wars, to any internal situations of violence until the end of the Second World War, until the adoption of the 1949 Geneva Conventions, when, as a compromise actually between two extreme approaches, one approach being that international law should continue to abstain from interfering into matters that can be described as an internal armed conflict, and the other extreme was that essentially the same regulation should be created, applicable simultaneously to interstate wars and internal armed conflicts. Then, as a compromise, the solution with Common Article 3 was created, and this common article for the first time set forth certain minimal rules that are applicable to any armed conflict, and first and foremost to an armed conflict not of an international character occurring in the territory of one of the high contracting parties. Now, this division was further reinforced with the development of international humanitarian law and with the adoption of the two protocols additional to the Geneva Conventions in 1977. These two protocols cover both conventions, but the difference between them is that Additional Protocol 1 deals with the protection of victims of international armed conflicts, whereas Additional Protocol 2 relates to the protection of victims of non-international armed conflicts. And this division remains important in international law today. This is how international law is being developed, and this finds lots of various manifestations, not only in the international humanitarian law, but also, for example, in international criminal law, in the part of the international criminal law which deals with war crimes. Without understanding the roots of this different approach to international and non-international armed conflicts, you would not be able to understand the structure of Article 8 of the Rome Statute of the International Criminal Court, which distinguishes between war crimes committed in the context of an international armed conflict and war crimes committed in the context of non-international armed conflict. Now, the main practical importance, the main practical consequence of this distinction between international and non-international armed conflict is, of course, the different body of norms of international humanitarian law and different sources of international humanitarian law that apply to each of them. Essentially, under treaty law, almost all of it, the entirety of the Geneva and The Hague law, apply to international armed conflicts, of course, with the exception of those rules that were specifically designed for a non-international armed conflict. For example, Of course, additional Protocol 2 to the 4 Geneva Conventions would only be applicable to non-international armed conflicts simply because it is designed exactly for them. But otherwise, the whole corpus, the whole body of international humanitarian law, treaty law, let me emphasize, applies to international armed conflicts. And the amount of treaty norms of international humanitarian law that apply to non-international armed conflicts is indeed very modest. It is essentially Common Article 3 to the 4 Geneva Conventions of 1949 and Additional Protocol 2 to those conventions of 1977. Common Article 3 is essentially a one-pager. It's in almost any book where the conventions and protocols are published, it would be placed just on one page. Even it occupies even less space than one page. Whereas Additional Protocol 2 is, of course, a separate treaty, technically speaking, but it only contains 28 articles altogether, and 10 of them are essentially of procedural nature. So it's less than 20, well, 18 to be precise, articles of Additional Protocol 2 which deal with the regulation of a non-international armed conflict. In addition, there are articles dealing with non-international armed conflicts. For example, in the 1954 the Hague Convention dealing with the protection of cultural property. It's Article 19 of the 1954 Convention, plus there are some additional articles which extend the application of the rules of international humanitarian law to non-international armed conflicts that can be found, for example, in an additional amendment, 2001 amendment extending the Convention on Conventional Weapons of 1980 and its protocols to non-international armed conflicts, or let's say the second protocol to the Hague Convention on the Protection of Cultural Property. There are also conventions which apply to any armed conflict, or they do not distinguish between those, such as the Biological Weapons Convention or the Chemical Weapons Convention or the Ottawa Convention prohibiting anti-personnel landmines. But otherwise, the main body of international humanitarian law when it comes to treaties is applicable only to international armed conflicts. And this, of course, applies to the 4 Geneva Conventions, except Common Article 3 and the first additional protocol to the Geneva Conventions. But luckily, of course, treaties is not the only source of international humanitarian law, and there's also customary rules. And the customary rules of international humanitarian law apply, most of them apply to both types of armed conflict, international and non-international. This is at least the conclusion of the customary rules study that was carried out by the ICRC in mid-1990s. It started mid-1990s and ended some 10 years later, then to be continued and updated on a regular basis. So the majority of the customary rules identified by the ICRC and the authors of that study, they are identified as rules applicable to both to international and non-international armed conflicts. And even though there's, of course, criticism of that study, I would say, by and large, it is accepted, and most of it is accepted as really a compendium of customary rules of international humanitarian law that reflect the opinio juris of the states, and also reflect the real practice of the states concerned. For me, one of the questions that I think should always be asked when we are looking at the distinction between international and non-international armed conflicts is whether it is still justified to keep the distinction. The problem is that, as I said already, sometimes it is difficult to distinguish between the two types of conflict. Sometimes the distinction is really artificial, and this is the case, for example, in the situation when some lawyers, including the ICRC lawyers, are suggesting to classify a situation as simultaneously an international and non-international armed conflict. And it is also clear that the reluctance of states to subject events happening on their territories to the rules of international humanitarian law is also something that is very old and coming from the history. So also when it comes to war crimes, sometimes it is really ridiculous why the same conduct in the Rome Statute, for example, if you read attentively Article 8 of the Rome Statute, the same conduct is criminalized for international armed conflicts and not criminalized for non-international armed conflicts. So with all this together, shouldn't we really fight for the abolition of the distinction between international and non-international armed conflicts? Well, there's of course a simple answer, yes, but the simple answer is never a good answer, because the situation is fairly nuanced, and the reasons for the maintaining the distinction between the two types of conflicts, they go actually beyond simply the humanitarian approach and the need to unify in a way applicable rules. For example, the rules that pertain to the international armed conflicts, that is to classical interstate wars, these rules are based on certain concepts such as, for example, combatants, prisoners of war, occupation. It is based on the premise that there is so-called combatant privilege or combatant immunity, meaning that those who fight in this war should not be held responsible for the very fact of participating in the war, in the armed conflict. And while this is certainly fine, or probably fine for interstate wars, and this very much corresponds to the doctrine put forward many years ago by Jean-Jacques Rousseau, essentially saying that soldiers are not enemies to each other, they're just there fighting for their states because it is the states who are fighting and they're not personal enemies. This is all, of course, fine, but in non-international armed conflicts, the problem is that it is virtually impossible to deny the right of any state to fight against those who took up arms contrary to the legislation of the state, trying to overthrow the government or trying to violate the territorial integrity of the state, and so on and so forth. So there one cannot say that such fighters, non-state groups, should always and automatically be given the combatant immunity, that they should be seen as lawful participants of the armed conflict. The states would never agree to this, and that would really also be incompatible with the positive obligations that every state has to make sure that there is law and order on its territory, that the state defends itself and defends the rights of persons who live the peaceful, normal, law-abiding life. Of course, such concepts as occupation, for example, are simply not applicable to non-international armed conflicts, because the territory does not actually go under any semblance of a lawful, even temporarily lawful, control by another belligerent party. So in essence, it is highly problematic to abolish the distinction between international and non-international armed conflicts straight away. However, I am personally convinced that this distinction should be gradually removed, especially when it comes to the substantive rules governing the conduct of hostilities. And in fact, I think that this is where IHL is going, and the developments with the customary rules of international humanitarian law demonstrate this very, very clearly. Also, when it comes to the treatment of persons, it is true that the status of combatants, of lawful participants, can hardly be accorded to the fighters of non-state armed groups, but the fundamental guarantees that those persons have when they are deprived of their liberty in connection to the armed conflict, they should in many respects be brought closer to the protections offered by the international humanitarian law. And on top of this, actually, one shouldn't forget that international human rights law would still apply. And for example, the protections that are offered to prisoners by the international human rights law, they are sufficient at least to maintain the very basic rights and the dignity of such persons. Of course, also one should understand that we are now in the period of development of international law where states once again, as it was the case previously, they view sovereignty as a virtue. They view sovereignty as something that they should be fighting for, sovereignty as something very good. And this is very much not what everyone was hearing from many international scholars, including international legal scholars of more liberal school, saying that sovereignty is detrimental, that sovereignty should be abolished. Whatever one thinks about it, it's quite obvious that in the short and medium term perspective, it is impossible to imagine that sovereignty would be abandoned. And if sovereignty is upheld, then of course the distinction between international and non-international armed conflicts is necessarily remaining valid. Let's now start with the qualification of international armed conflicts. And the basic rule of international humanitarian law, the basic norm, can be found in Common Article 2 to the 1949 Geneva Conventions. This article was further amended by Article 1 of Additional Protocol 1 to the Geneva Conventions, which essentially made a reference to the situations covered in Common Article 2, with also one addition of wars of national liberation that has not, to be frank, had a very significant impact on the development of international humanitarian law when it comes to the classification of armed conflicts and to the correct qualification of international armed conflicts. When we read the text of Common Article 2, we see that it mentions three different situations, all of which could be qualified as an international armed conflict. So it says that the present convention shall apply to all cases of declared war, this is one, or of any other armed conflict which may arise between one or more of the high contracting parties, even if the state of war is not recognized by one of them, this is 2, and the convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the said occupation meets with no armed resistance, and this is 3. So we have 3 situations: declared war, effective armed conflict, and occupation. Now let's go through these 3 situations. Now the mentioning of declared war is probably necessary nowadays, because there is still a need, albeit a limited one, to apply IHL or some rules of the IHL to situations of declared war when, in fact, no armed hostilities take place. But it is first and foremost, in my view, due to the history of international humanitarian law, because previously the law of armed conflict, or IHL as we know it now, this was the law of war, and the law of war should apply to war. And the concept of war was important in international law before the Second World War, because it was the opposite of peace. So international law, you remember from the books by the fathers of international law, such as Alberico Gentili or Hugo Grotius. They were all called law of war and peace, law of peace and war, and it was clear that these two modes of operation of international law were distinguished. In addition, a formal declaration of war was a requirement set forth in the Third Hague Convention relative to the opening of hostilities of 1907. And the formal declaration of war was of great importance because it triggered the application of the laws of war. It triggered such things as the law of neutrality and so on. Nowadays, of course, it is less frequent that states would be formally declaring war to each other. In fact, they do it extremely rarely, almost never. But nevertheless, this situation, the situation of a declared war, is mentioned and is considered to be one of the situations where international humanitarian law is applicable. And there is a necessity, for example, to make sure that there's no abuse of citizens of the hostile state which found themselves in the territory of a state which has just declared war to their state, or to which their state has declared war. So this is the first situation, which is probably the simplest of three. Now, as regards the actual armed conflict, well, the very term of armed conflict was introduced into the Geneva Conventions in 1949 precisely because the idea was to abandon this super important term of war with lots of meaning and lots of procedures around it, but instead to see the conditions for the application of the law that is called in Latin jus in bello, that is what we call now international humanitarian law, to make them a purely factual thing. So an armed conflict is a factual thing. When there is recourse to force in international relations, then there's an armed conflict between states, but also, of course, armed conflict, the notion of armed conflict is applicable to non-international armed conflicts, to the application of force or mass violence within a state. As I have already mentioned, international humanitarian law, at least the treaty law, does not have one single concept of an armed conflict. It is a custom nowadays in textbooks of international humanitarian law to quote a paragraph from the ICTY appeals chamber interlocutory appeal judgment or decision in Tadic, where it tried to give a synthetic notion of international humanitarian, of an armed conflict, which is of course useful, but at the same time this is still the position of the appeals chamber of the ICTY. So even though it is a handy text, I wouldn't attach that much importance to this piece of text, and you are most welcome to acquaint yourselves with it. I will not be reading it out now. The question, though, with the armed conflict of an international character is whether there is a threshold of violence. So what kind of armed force, what kind of violence should be there for us to conclude that there is actually an international armed conflict? And paradoxically, even though one can think that there should be such a threshold, and I would also say that logically there should be such a threshold, in fact, in law, the most popular position of authors on international humanitarian law is that there is actually no such threshold, doesn't exist for international armed conflicts. So whenever there is resort to armed force between states, then we have an armed conflict. I personally think that this might be going a little bit too far, but the danger of an opposite approach is that there might be gaps in protection of persons who need protection, in protection of victims of any application of armed force between states, if we try to specify what the threshold should be present. And this is still a difference from non-international armed conflicts, where this threshold is actually required, and we will speak about this in a short while. So any application of armed force between states is an armed conflict, and the convention says that even if one of them does not recognize this, and it is also established, I think, in jurisprudence and in the doctrine that, in fact, it doesn't matter what states say about the application of force. It is a factual thing. If one state applies force against another state, we have an armed conflict, an interstate armed conflict. And the third situation is occupation. By occupation, I mean belligerent, or as sometimes they say, also military occupation of the territory. It is a complicated subject, and I hope that you have or will be able or have been able to study this in more detail, especially for Ukraine. It has a very direct relevance. But here, suffice it to say that whenever there is partial or total occupation of the territory of a state, even with no armed resistance, for example, because the state is not in a position to defend itself, because it has no armed forces, or they are too weak to offer any real resistance, or for any other reason, indeed, then we can say that there is an international armed conflict, and the international armed conflict will continue until the occupation ceases, until the occupation is completely ended. The definition of occupation can be found in Article 42 of the 1907 Hague Regulations, which says that the territory is considered occupied when it is actually placed under the authority of the hostile army. And whenever this occupation, then of course the relevant provisions of international humanitarian law apply. In terms of treaty law, this would be the Hague Regulations, which of 1907, which have a separate chapter dealing with belligerent occupation, and of course the fourth Geneva Convention dealing with the protection of civilians, of the civilian population, in particular in the situation of occupation. Certainly there are lots of nuances concerning the law of occupation, and let me just reiterate that they deserve very close attention, and they need to be the subject of a separate discussion, hopefully within this summer school. Now, I've already mentioned that Common Article 2 was kind of amended by Article 1, paragraph 4 especially, of Additional Protocol 1. Why paragraph 4? Because paragraph 4 suggests the fourth situation where the law of international armed conflicts should apply, and this is the situation when peoples are fighting against colonial domination and alien occupation and against racist regimes in the exercise of their right of self-determination. I must say that this provision has had very limited impact on the development of international humanitarian law. It was primarily aimed at a few concrete situations, such as the situation in South Africa and Rhodesia, as it was then called, and the various colonial struggles of the time, and especially the experience of states which just emerged as newly independent states following the decolonization. And of course, states also meant of the Israeli occupation of Palestine. This provision is one of the reasons why Additional Protocol 1 is less popular than the Geneva Conventions. You know, the Geneva Conventions are ratified universally, and this is not the case with Additional Protocol 1, not only because of Article 1, Paragraph 4, but in particular perhaps because of that. And in addition, I must say that the legal technique employed here is very problematic, because it speaks about people fighting against colonial domination and alien occupation and racist regimes. So one can even go as far as try to contend that, in fact, there should be all the three present at the same time, which is perhaps quite over the top. Anyway, this provision is, formally speaking, binding on the states parties to Additional Protocol 1, which is the majority of states. But once again, one should never overestimate its importance. And whenever we have student competitions on international humanitarian law, when somebody is trying to invoke Article 1, Paragraph 4 of Additional Protocol 1, that would usually be seen very skeptically by the authors of the case and also by the jury. But once again, it depends, of course, on a particular situation. Now turn to non-international armed conflicts. As I have already mentioned, they, in terms of treaty law, are governed first and foremost by Common Article 3 of the 4 Geneva Conventions of 1949 and by Additional Protocol 2 of 1977. Now, the difficulty here is that there is a difference in the scope of application between Common Article 3 and Additional Protocol 2. And Common Article 3 applies to a wider circle of situations than Additional Protocol 2, which includes additional requirements which are not present in Common Article 3. So, in practical terms, I would say that a non-international armed conflict exists when the criteria of Common Article 3 and customary international humanitarian law are met. And on top of this, of course, some of those conflicts are also regulated by Additional Protocol 2. So, speaking of Common Article 3, I need to say, first of all, that, of course, I expect you to read it or to have read it already, but you probably know or will know that it contains a set of minimum requirements, of minimum humanitarian obligations, which have to be respected in all circumstances, and this is very important, all circumstances. So the threshold of applicability for these safeguards, for these humanitarian obligations, is really low, and this is very well justified. However,
albeit the criteria are in fact quite low and relatively easy to meet. Still, they are more restrictive than for international armed conflicts, because for international armed conflicts we have at least two states, and when there is use of force between these two states, then certainly international humanitarian law pertaining to international armed conflicts is applicable. And here there is a requirement for the conflict to gain a certain degree of intensity. This is not directly mentioned in Common Article 3, but it is in fact almost impossible to apply it forgetting this criteria. Now, the criteria that we have in Common Article 3, they are very simple. It simply refers to an armed conflict, not of an international character, occurring in the territory of one of the high contracting parties. So essentially, there's a possibility for any armed conflict between a state and an organized armed group, or between the two organized armed groups in the territory of the state, to be considered as non-international armed conflict covered by Common Article 3. In practice, however, we should understand that there would be necessary requirements for these non-state armed groups to be described as such and to be recognized as such, and this means that they should display a minimum of organization. So it's not just a crowd of people. There should be a command, there should be a hierarchy, there should be somebody who is responsible for the action of the subordinates, there should be military discipline, they should be capable of respecting the rules of international humanitarian law, they should be capable of carrying out concerted military operations, or at least organized military operations. And the second criterion that is not directly in the text, but it is almost inevitable, is the minimum of intensity that I have already mentioned. So there should be some, serious violence which can be only described as an armed conflict. Now, how do you know whether it is an armed conflict, a non-international armed conflict, or it is simply a riot? I will come back to that a bit later, but sometimes in certain books you can find the following piece of advice, just as a rule of thumb, because you will never find this in the convention. Whenever a state is not able to quell a certain riot, to reinstate law and order in its territory, simply with its police forces, when it has to resort to the use of the army, then it is highly likely that we are dealing with a non-international armed conflict. Once again, this is not a precise legal criterion. This is just a rule of thumb. This is something that would strongly suggest that you are probably dealing with a non-international armed conflict. Now, for additional protocol 2, there are much more detailed descriptions of when this document applies. And it says essentially that the protocol shall apply to all armed conflicts not of an international character, so not covered by additional protocol 1, that is, which is not an international character, not an international conflict. Then it should take place in the territory of a high contracting party between its armed forces and dissident armed forces, or other organized armed groups, which, under responsible command, exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations and to implement this protocol. So we see that the material scope of application is more restricted than for Common Article 3, at least in two main respects. First, the rebels or the non-state party to the conflict must control a part of the territory of the state. This condition simply does not exist under Common Article 3. It does not exist under customary international law. It is purely a condition for the application of Additional Protocol 2 as a matter of treaty law. And secondly, Additional Protocol 2 applies only to relations between the state army, the state armed forces, and the non-state groups. So a conflict state, non-state is covered, of course, if other conditions are met as well. But when we have two different armed groups, non-state armed groups, the violence between them, which certainly reaches the threshold of an armed conflict, will not be regulated by Common Article, by Additional Protocol 2, only by Common Article 3. Now, this is very, of course, simple and superficial, but I would still think that you understand the difference. Once again, for me, the way to check which of the two definitions is more appropriate, Common Article 3 or Additional Protocol 2, would be to look at the relevant provisions of international criminal law, especially of Article 8 of the Rome Statute of the International Criminal Court dealing with war crimes. So Article 8 of the Rome Statute essentially adopts the definition of a non-international armed conflict under Common Article 3 as amended by customary rules, so requiring the intensity, requiring the also the minimum organization of the non-state actor. Okay, but sometimes, and actually quite often, the situations that can be characterized as a non-international armed conflict are, so to say, internationalized. So there is also an involvement of another state. And here this is a problem which is very common for the 21st century and sometimes it is referred to as the so-called hybrid conflict. So when there is visibly, more visibly or less visibly, also a foreign party, a foreign state, which somehow interferes in the conflict between the government, armed forces, and non-state, anti-government, or dissident, as Additional Protocol 2 puts it, armed forces. So we essentially have two situations: a foreign intervention on the side of a state against the armed group, and the intervention on the side of a foreign intervention on the side of a non-state armed group against the state. The first one, when a foreign country comes invited by the state to help it to deal with the rebels or with anti-governmental armed groups, is fairly simple because the situation remains, legally speaking, a non-international armed conflict. What is more complicated is foreign intervention on the side of the non-state armed group. And here there's a huge discussion which also merits a separate conversation, a separate lecture, as to the degree of control that a foreign state must exercise over a non-state armed group to render the conflict an international one, to become responsible for the actions of the armed group. You have probably heard about the discussion between the International Court of Justice and the International Criminal Tribunal for the former Yugoslavia in terms of the applicable tests, that is, the applicable sets of criteria to establish the control of a foreign state over a non-state armed group fighting the government in the territory where it is located. You probably know, and if not, I will just mention briefly that the International Court of Justice here is basing its argument also on the articles on the responsibility of states for international responsibility of states for the internationally wrongful acts. And it puts forward the doctrine of effective control that is required for this to make the state responsible for the actions of an armed group, and also to render the conflict an international armed conflict instead of a non-international armed conflict. And the ICTY position expressed by the appeals chamber in the Tadic case is that the control should be simply of an overall nature, and the overall control would be sufficient to qualify the situation as an international armed conflict. Now, there is a separate discussion whether these two approaches are compatible or not. In essence, they are not, even though there have been attempts by the International Court of Justice in the 2007 judgment on in the genocide case, Bosnia and Herzegovina against Serbia and Montenegro, to say that in fact it's okay to apply effective control to the issues of state responsibility and overall control to the qualification of armed conflicts. But I tend to agree with those authors who think that this is still not a very good solution, because if we qualify the conflict as an international armed conflict based on the overall control doctrine, then it follows also that the state should bear international responsibility for the actions of the non-state party that it controls. Otherwise, there is a gap of responsibility. No one is responsible then for, no state is responsible for the action of this group, and this is not really compatible with the necessity to apply international humanitarian law and for the state to discharge its obligations under international humanitarian law. So this is a very complicated subject, I would say, and I don't see a ready solution available. It is clear that gradually there is a tendency to accept the overall control doctrine as the main doctrine here. And this is what has happened essentially with the International Criminal Court, which has accepted the overall control doctrine. Nevertheless, I tend to think that the International Court of Justice will have to change its jurisprudence when there is a suitable opportunity to do so, and to accept the overall control doctrine. But it is easy to say that this is a solution, but it is not very easy to predict when and whether at all the International Court of Justice would be actually prepared to do so. And last but not least, other situations of violence. Well, other situations of violence which do not actually cross the threshold, which do not reach the threshold for the application of international humanitarian law, they are not those where IHL should be applied, full stop. So even though there is large-scale violence, but, for example, the armed groups in question, they do not have any organization, or there are situations that are described in paragraph 2 of additional protocol of Article 1 of Additional Protocol 2 to the Geneva Conventions, namely the situations of internal disturbance or frictions or tensions, such as riots or isolated or sporadic acts of violence, then IHL is not applicable. Is it a problem that IHL is not applicable? Well, certainly the domestic law is applicable. In terms of international law, international human rights law is applicable. And the protections offered by the international human rights law are, in fact, not weaker than protections offered by the international humanitarian law. It is one more subject which should be discussed separately, the interplay between international humanitarian law and international human rights law. But let me just say that, in fact, protections and standards of international human rights law are higher. The problem, though, is that it is difficult to wage a war simply being guided by international human rights law. The threshold, for example, for the application of lethal force in normal sort of life, in peaceful life under international human rights law, they are much more stringent than the application of lethal force in international humanitarian law, where you essentially can do that against a combatant of the opposing party, of the enemy. So I think that overstretching the applicability of international humanitarian law would not make much sense in this respect. Even though I must say that the cross-fertilization, so to say, of international human rights law and international humanitarian law does take place, and certain approaches, certain standards of, let's say, of IHL are sometimes applied in the context of the of international human rights law. But as I said, this is a separate subject. So to conclude, this has been a very brief and quick overview of the applicability of international humanitarian law in various situations of violence to which actually it applies. And I'm sure that this is the question which you will revisit many times, because ultimately you cannot build any convincing argumentation based on international humanitarian law if you do not qualify the situation as an armed conflict, and if you do not convincingly also qualify it as an international or non-international armed conflict, or perhaps even both, even though I'm not a big fan of that solution. I'd like to thank you once again for your attention and for the invitation, and I hope to be able to record some answers to your questions in another video. I wish you and the summer school the best of luck. Thank you very much.